Welcome to the ARPA Benefits Compliance Updates and FAQ. Thank you all for joining us. Our benefits compliance team will be moderating today's call, led by Jill Brooking. At the end of the call, please post your questions in the Q&A as opposed to the chat. We will try to get to as many of the Q&As as we can in the time allotted after the main discussion. If you are unable to stay on the call, today's presentation is being recorded and will be emailed tomorrow. The recording and slide deck from this webinar will be posted to the NFP Latest Insights page under Webinars Training section. At this time, I would like to introduce our speakers for today's webinar. Joining us today are Beth Allen, Vice President and Counsel, and Diane Cross, Vice President and Counsel from NFP's Benefits Compliance Department. We are very excited to have them speaking with us today. It is my pleasure to hand over the call to our speakers. Beth, the floor is yours.
Thank you so much, Amber, and welcome everyone today to the Benefits Compliance Updates and FAQs Part 6. If you have been with us for a little bit, then you were probably here for Parts 1 through 5. And here we are with another part that I would like to think is going to be the final part, but we're not quite sure about that. So, we'll see kind of what happens, but thank you for joining us today. As always, the information that we're going to provide today is just informational in nature, and it is not tax or legal advice. And so just keep in mind that that's always going to be the case for all of our presentations. So the main point of today's talk is really just to talk about the most recent IRS notice on the ARPA COBRA subsidies, okay? And so that's kind of the first piece and the biggest piece that we're going to be discussing. But by the end of the call, we're also going to just discuss some status updates, if you will, from some of the other ARPA guidance, just to kind of make sure that you understand kind of where we are in the process on those particular provisions of the ARPA. And then we'll end that out with some final thoughts on implementation. And as always, we try to provide you with some resources. Jill Brooking is going to be serving as our kind of main moderator today. And so she, along with the rest of the benefits compliance team, will be answering questions in the Q&A. So please put your questions in the Q&A if you have questions for us as we go along. So with that said, I'm going to jump into just issues addressed by IRS Notice 2021-46. And this particular notice is one that we got from the IRS. It came out at the end of July 26th. And this was the second notice that we kind of got from the IRS that answered different questions about the ARPA COBRA premium assistance. And so it provided some clarification on various points. If you remember back to the last one that we got, which I believe was 2021-31, that was like 80 something questions. This one is not as detailed. There's only 11 questions in this one, but we're going to take some time to go through each of those questions and answers and just give you an idea of what the IRS was saying when they put this notice out. And so very specifically, there are three parts, kind of, if you will, of the notice. The first one has to do with eligibility for COBRA premium assistance, and that's just Q&A 1. There's another section, if you will, on end of COBRA premium assistance period, specifically having to do with dental and vision coverage. That's going to be Q&A 2. There's a quick question, Q&A 3, that has to do with state continuation and what that looks like if there's a particular state where a subset of state residents are covered on state continuation. And then the bulk of the questions in the Q&A this time have to do with actually claiming the COBRA premium assistance credit. And obviously that is kind of a timely conversation to have because all of the entities out there that are going to be considered that premium payee would potentially be already claiming that credit. And so the guidance that the IRS gives us around this, again, is very timely. And for each of those Q&A, we're going to discuss kind of it from 3 standpoints. If most of you have been on these presentations with us, we kind of try to put it in language where you kind of understand what you're supposed to take away. So for each of those Q&A, we're going to discuss what the IRS basically said, to whom the question actually applies, and the significance of the guidance, okay? So when we have that piece that kind of talks about to whom this question applies, there are going to be some of you who are going to say, well, that's actually not us, right? Like it doesn't apply to us. But theoretically, it could happen to where it does happen later, depending on the AEIs that you are dealing with, or if there's any kind of changes to your business structure. So you do want to definitely pay attention to all those questions, even if it technically doesn't apply to you now. So I'm going to go ahead and jump in with the first Q&A that Notice 2021-46 provides. And basically what the IRS said on this one is that the COBRA premium assistance is still going to be available to AEIs if their original 18-month COBRA continuation period expired, but they're entitled to request an extension due to something like a disability, a second qualifying event, or state continuation. And so this is actually a question that I think we had some questions about how this would work and the mechanics of it, if there was state continuation or if there was a situation where someone got that extension of COBRA to the 29 months that is provided through, because of a disability. And so this question is here to kind of, explain that to us. And so as far as to whom it applies, it's really going to apply to any assistance eligible individual or AEI who might have a chance for their original 18 months to go on longer because of some circumstance. Okay. And so that could be, again, a disability. It could be a second qualifying event or state continuation. But the rule is still going to basically limit it to the people who had their original triggering event as a reduction of hours or an involuntary termination. And so that's important to note that if their original qualifying or triggering event was something besides a reduction in hours or involuntary termination, this rule is not going to function to also make them eligible for the COBRA premium assistance. The significance of the guidance on this one, and we're going to talk about an example really briefly here, is that the extension of certain timeframes kind of comes up again. And I think ultimately it's going to mean that individuals that are entitled to these extensions of the maximum coverage period are going to have another chance basically to elect that additional coverage and premium assistance that would go with it. So with that, let's kind of jump into an example that the Q&A one actually gave us. And so with this, an individual was involuntarily terminated, right? So they're going to be eligible or considered an AEI. They were involuntarily terminated 10/1/2019. Their COBRA maximum duration period, or the original, let's say 18 months, would end March 31st, 2021. Okay. However, on March 1st, 2021, the Social Security Administration deems that individual disabled and takes their disability all the way back to 11/1/2019. Okay. When you have that extension due to a disability, that's going to entitle the individual to 29 total months of COBRA instead of 18. So that's an additional 11 months that person is going to have access to. However, in this fact pattern, the individual fails to notify the plan of the Social Security Administration determination by 4/30. Okay. And that's significant because normally if someone has, let's say, a disability determination, they're going to have 60 days to notify the employer that that occurred so that they could continue that COBRA for that additional amount of months. Okay. But the result of what we have from the ARPA and other guidance is that because of the extension of certain timeframes, that individual does not just have 60 days to notify the plan, they actually have 1 year plus 60 days. And so remember with the extension of certain timeframes, that was people who could make COBRA elections. They now had up to an additional year to essentially make that COBRA election. And so if this happens in this case, that individual would be able to notify the plan on April 10th, if that's when they got around to doing it, and they could elect that coverage from 4/1/2021 on. And so, in other words, as long as that person was eligible to actually be an AEI and was not covered by Medicare or other group health coverage, they could potentially go back and elect COBRA for that extended period with the premium assistance. And so that's kind of two different concepts with the extension of certain timeframes, but then also the extension based on the disability that you want to keep in mind. But that's what the IRS was saying with this particular question. Moving on to question 2, the end of the COBRA premium assistance period or dental and vision coverage. This question was getting at situations where, let's say, an AEI had elected COBRA for only dental or vision. And the question was basically, do they stop being AEIs if they become eligible for other group health benefits or Medicare that don't actually offer dental or vision? And so again, this was another question that we kind of didn't quite know what this meant, but what the IRS basically said is, basically, if you are eligible for any group health plan coverage, that's going to be disqualifying. And so it doesn't matter, for example, if the specific group health plan coverage that you are eligible for is not the group health plan coverage that you elected for COBRA. And so really any employee or assistance eligible individual who becomes eligible for other group coverage or Medicare is going to potentially have this situation where the COBRA that they elected, no matter what they elected it for, is no longer going to be, eligible for the premium assistance. The next question, I think, doesn't have a whole lot of application. It's something having to do specifically with state continuation. If you remember with the ARPA, one of the requirements is that the ARPA COBRA premium assistance provision would apply to state coverage where that coverage was comparable to what was offered under federal coverage. And so this particular Q&A says that state continuation requirements that only cover a subset of state residents is still going to be comparable coverage for ARPA purposes. And so any state out there, I guess, that has continuation provisions that might be limited to certain residents, the IRS talked about certain states that might only provide continuation to government employees. That is still going to be coverage where they're going to be able to access the COBRA premium assistance. So that's not going to keep them out of being able to access that. And so state continuation is still going to be subject to ARPA, even if it's not broadly applicable to all employers in the state. And so again, I think that probably has very limited application, but if that is the case in certain states, those entities that do offer that continuation are still going to have to provide the COBRA premium assistance. So that's Q&A 1 through 3, and I'm going to invite Diane to discuss the next several Q&As.
Hey, thanks, Beth. And as Beth queued up at the beginning, Q4 begins our discussion where the IRS starts providing clarification on which entity can claim the tax credit. So what the IRS says through Q&A number 4 is that the common law employer, who is the one that can claim the tax credit, is the current common law employer for those AEIs whose hours have been reduced, or the former common law employer for those AEIs who were involuntarily terminated. And I'll take a pause here too, because I do realize that our industry is very heavily acronymed. And for folks who might be joining for the first time, I just want to reiterate that when we say AEI, it's an assistance eligible individual. And I think Beth mentioned that a few times, but we use that reference quite a bit. So I just wanted to clarify that that would be an assistance eligible individual who is maybe eligible for COBRA premium assistance through ARPA. But who does Q&A number 4 apply to? And that would be every employer subject to these ARPA's COBRA premium assistance provisions. We're not lighting the world on fire here with the guidance provided in Q4, but it does set the stage, as you'll see as we go through Q5 and 11, for exceptions that might apply to this main premise. And those exceptions, as we'll discuss, deal with determining who the common law employer is when there's a third-party payer, you have a business reorganization, and dealing with state agencies. But bottom line is Q4 gives our baseline in that the common law employer is the current common law employer for AEIs when you have individuals who have a reduction of hour, or the former common law employer for AEIs who are involuntarily terminated. Next slide, please. All right, so Q5 goes on to provide some, what I think is noteworthy guidance. It reiterates that the common law employers that are subject to federal COBRA are the premium payees, and this is true even when the group health plan is subject to both federal COBRA and state mandated continuation coverage. The noteworthy part here is that this is true even if state continuation requires the AEI to pay premiums directly to the insurer after federal COBRA is exhausted. So I'm going to take a pause and really dissect what Q5 is saying here. First, does this apply to? It applies to employers that are subject to federal COBRA that may be in states where there's state continuation that extends beyond federal COBRA. So examples off the top of the head would be New York and California. Generally speaking, for fully insured plans, subject to state continuation, the carrier is the entity that's entitled to claim the tax credit. But this guidance that's provided through Q5 is describing that specific set of circumstances where that might not be the case. So mechanically, this is an issue if think during the state continuation, insurers, subject to that state continuation are in the practice of taking the employer out of the equation once federal COBRA ends. It's very common that we see when an employer step out of the equation when federal COBRA is exhausted, that it would be between the individual and the insurer. So the employers where states, employers who are located in states where state continuation extends beyond federal COBRA really should be aware of this specific Q&A. Next slide, please. And then onwards to Q6, the IRS is explaining that companies who are in controlled groups with several different common law employers, each separate common law employer will be the premium payee that will claim the COBRA premium assistance for their particular employees. And so this applies to the non-multi-employer plans where a group health plan is covering a controlled group of companies. And this makes sense because it's very similar to employer mandate and reporting requirements. Each individual employer or each member employer or each EIN is eligible for and claims the corresponding tax credits. Also aligns with payroll tax rules. So the bottom line here is where a controlled group exists, ARPA premium assistance tax credit for premium payee purposes applies separately per employer. Next slide, please. And here we're going to see very similar guidance, but a different scenario. So now we're dealing with a non-multi-employer group health plan that's subject to federal COBRA, but covers employees of two or more unrelated employers. Still reiterating that the common law employer of the AEI will claim the tax credit. So who does this apply to? It would be those non-multi group health plans with different unrelated employers. For a simple example, think AMIWA. And here it's just consistent. The running theme is that the premium payee is the common law employer. And this doesn't change even when the mechanism through which the plan is offered may change with that controlled group or AMIWA. Still, the bottom line is that that premium payee is the common law employer. So I'm going to hand it back over to Beth for more clarification on this topic of which entity can claim the tax credit.
Thank you, Diane. And you really did set the stage on this conversation that's ongoing, where the general rule is that the common law employer is the one who is going to claim the credit. But then it's kind of funny because the IRS then continues with kind of some examples where the common law employer may not be the person or the entity that is entitled to the credit, or where there's some kind of kink in, what that rule is and what it looks like for different entities. And so following that up with Q&A 8, this is a situation where we have an entity that basically is a third-party payer. Okay, so this piece speaks to like PEOs, CPEOs, or MEWAs. And what the IRS basically says is that an entity that provides benefits to the employees of another entity, but is not a third-party payer of those employees' wages, will not be the premium payee for any AEI's COBRA premium assistance. And so the idea again emerges that, you might have a third party who does provide, let's say, COBRA to certain AEIs, but that entity is only going to be an AEI if they are also kind of the payer of the employee's wages. And I think the point there is, again, that, although this is an exception to the main rule, one of these type of entities is only going to be the entity that's going to claim the credit if they're also an entity that basically pays payroll taxes on behalf of that particular person. And so it's one of those things where you're going to follow the taxes again. Now, most of the time, that is not going to be a MEWA. You will find situations where it is a PEO, and PEOs can even be considered a MEWA, depending on what the design is. But the point is that you're really only going to be dealing with that situation as it pertains to PEOs and other entities that kind of claim, let's say, a joint employment situation where they are actually also the entity that pays the payroll taxes for these particular employees. And so the IRS gives an example for Q&A 8. And basically, it's a situation where what you have is a MEWA, and you have employers A and B who participate in a MEWA. But the MEWA does not pay the wages subject to payroll taxes, nor report on those wages or taxes on behalf of A and B. So it's just a regular MEWA where employers like A and B come to the MEWA to receive, let's say, their group health plan coverage, but they don't actually rely on the MEWA to do anything else for them, especially taxes. And so let's say that certain past employees of A and B are AEIs with regard to the coverage that's actually provided through the MEWA. And so this question makes it clear that although the MEWA here is a third-party payer, right? So they are actually the entity that might be, let's say, funneling the COBRA money for the COBRA participants on the plan, they're not going to be entitled to the premium or into the premium assistance credit because they're not really the premium payee that's going to be entitled to that credit. Okay. And so because they didn't actually file taxes on these people or do that, they are not going to be the entities that would claim that credit. Instead, in this example, employer A and B are going to be the premium payees entitled to that assistance for their employees or the employees of A and B. Now, this is going to be interesting, I think, from the standpoint of administratively what this looks like, because often if you have a MEWA that is going to be subject to COBRA, then the MEWA does actually, let's say, take control of that process and they kind of work with the COBRA vendor to make this happen. And so in the event now that you have these employers who are going to have to be the ones who claim the credit, mechanically, that might be a little bit interesting, but I'm sure that this is something that MEWAs are working on in conjunction with their employer members. So going on to Q&A 9, it brings up another concept in helping us to identify kind of who the entity is that can claim the credit. And so with this particular Q&A, basically the IRS said that in M&A or merger and acquisition transactions, if the selling group, and so the group that is selling their company, let's say to a buyer, remains obligated to provide COBRA continuation coverage to COBRA qualified beneficiaries that are affected by the sale, then the selling group is going to be the premium payee. Okay, so this is going to apply to any entity out there where there are parties to the transaction where the seller is going to continue to offer a group health plan post-transaction. This is where kind of the IRS gives us an idea of who is going to be claiming that credit specifically in that situation. Now, it's interesting that the IRS did not actually choose to answer the question kind of the other way, where the seller is not going to continue to offer a group health plan. But then kind of, and I'll talk about in a second why they may not have done that. But theoretically, then you have a buyer who is going to be the one that would be on the hook for COBRA. And so generally that would seem to mean that that buyer would be the one that would be the premium payee in that situation. But we'll talk about that just a little bit more when we talk about the default COBRA rules. And so the significance of this guidance is that really the status of the premium payee in M&A situations is going to follow the entity that's required to offer COBRA. Okay, and so that could potentially, result in an exception to the general rule that the premium payee is the common law employer if, for example, the seller doesn't actually continue a plan. Okay. So I think that's a good place, though, to stop and just talk about the default rules for COBRA as it pertains to just who should be offering coverage after a transaction. And mind you, I always have to pause when we start to talk about things like this, because although these are the default rules, the parties to the transaction can actually decide kind of how they want COBRA to be dealt with to an extent, okay, because it's kind of limited, but they could potentially decide. And we also try to stress that it's really important that employers who are engaging in a lot of M&A transactions work with legal counsel who help you understand kind of what the requirements are here, because it's very difficult. And a lot of parties who aren't looking at this until, let's say, after the transaction kind of realize that there might have been some things that fell through the cracks. Okay, so you want to watch out for that and work with counsel if you can. And so as it pertains to the default rules from the IRS on M&A situations and COBRA, they look at stock purchases differently than asset purchases. Okay, with stock purchases, the buyer is going to be purchasing all the stock or ownership in the seller's business. Employees then of that purchased business or the business that was selling are going to continue to be employed by basically the same legal entity, okay? But the ownership of that entity is basically transferred from the seller to the buyer. And so that's what happens there. Now, interestingly, the default COBRA rules are going to say that if the selling company maintains any group health plan after the sale, then they are going to be responsible for offering and maintaining COBRA. Okay, and so in the context of what we're talking about, if that seller maintains that group or that group health plan, then basically they're going to be responsible for providing COBRA, and they're going to be the ones that would claim the premium tax credit or the premium credit, premium assistance credit. And so that is kind of what would happen if that seller keeps the group health plan. If it does not, okay, then potentially any terminated employees as it pertains to a stock purchase and any present COBRA participants under the seller's plan would be eligible to continue COBRA coverage or coverage through the buyer's plan. Okay. And so that's generally how that's going to work. And that might switch the obligation to provide the COBRA premium assistance to the buyer in that situation because the seller basically doesn't have a health plan that exists. Okay. The asset purchase rules are slightly different because the buyer is purchasing some or all of the seller's assets, and employees of the purchase entity are generally going to be terminated by the selling group and then rehired by the buyer. And so it's slightly different. Now, that kind of default rule that if the seller maintains a group health plan, that's going to still apply, that they're still going to be the ones that are going to be required to provide COBRA. However, if the seller does not keep or maintain a group health plan, then any terminated or employees that are not rehired and any present COBRA participants under the seller's COBRA plan would be eligible to continue coverage through the buyer's COBRA plan. But that's if the buyer is a successor employer. Okay, and so there's like a definition of like the successor employer. And again, this gets very difficult. And so it's really important for you to consult with counsel if you can on these obligations. But generally, this is how those rules are going to work. And again, that's generally also going to determine who is going to be able to access that premium assistance credit as it pertains to the requirement to offer coverage through ARPA. So there were a number of you who might have had questions for us about, well, who's responsible to provide this ARPA COBRA premium assistance if we have a situation where a client or a company, bought some other entity at the end of last year or at the beginning of this year. And so really that obligation is going to follow the COBRA default rules as it pertains to M&A situations. So kind of just to quickly go through the last couple questions, question 10 had to do with if there were states who make COBRA coverage or continuation coverage available to various agencies or local governments that are kind of, let's say, outside of the state as an entity, or I shouldn't say outside of the state if they are not like specifically the state, but there are other, let's say, agencies or local governments. If they make that, if they're actually the ones that are obligated to offer COBRA to those various agencies or local governments, and if the AEIs would have normally paid the state directly for that coverage, then the state is going to be the premium payee, even though it's not the common law employer of those employees. And so we don't have a lot of clients who are necessarily state governments. However, those local governments who are our clients, this is going to matter if you have an arrangement through which you work with the state or the state actually provides the coverage that is provided to your COBRA beneficiaries. And this is just kind of another exception, if you will, to the general rule that the common law employer is the premium payee. And then finally, the last Q&A has to do with the situation where a small employer has a shop plan. And again, limited application, because this is really just employers that might have plans offered through the shop. But basically what the IRS said is that if certain conditions are met, and there's going to be 4 requirements that'll be on the next slide. If certain conditions are met, an employer with less than 20 employees is going to be the premium payee for AEIs that are offered COBRA through the shop. Okay. Now, this is slightly an exception to the general rule that the insurer is the premium payee for plans that are not subject to only state continuation and not federal. And so, or that are subject to only state continuation and not federal COBRA. And so this is, a situation where you might have that small employer actually claiming the credit instead of the insurer. And it only would happen if there are these 4 requirements that are met. The first one being that the employer participates in a shop exchange that offers multiple insurance choices to employees enrolled on the same small group health plan. That is normally the case. But I guess that, that would be different than if they were offering, let's say, participation in the shop and there's only one choice. But if they're offering participation in the shop and there's multiple insurance choices, then that's one of the requirements that has to be met. The shop exchange would have to provide the participating employer with a single premium invoice and aggregate all premium payments, and then allocate and pay the applicable premium amount to the insurer. And so that's how that would kind of work potentially as far as the funding mechanism of it. A third requirement is that the participating employer has a contractual obligation with the shop exchange to pay all applicable COBRA premiums to the shop exchange. And then finally, the participating employer would have received the state mini COBRA premiums directly from the AEIs were it not for the COBRA premium assistance. So these kind of 4 requirements or conditions are what must be met in order for that small employer that's participating on the shop to actually claim the tax credit that's associated with the ARPA COBRA premium assistance. So those are the 11 questions that the IRS went through. Again, kind of very specific applications to certain people and definitely not broad application to a whole lot of employers, kind of with the exception of, the first 3 questions and then the very specific question having to do with common law employers and that general rule. But it does provide some clarity on a number of different things that we might have still had questions about. So with that said, Diane, I am going to invite you to just talk about kind of the status of the ARPA COBRA Premium Assistance compliance.
Why, thank you. And with that being said, we are all likely very well aware that we're in the midst of the time frame that the ARPA COBRA Premium Assistance applies. I think that's why we're all conducting this webinar or attending the webinar, but the applicability of ARPA COBRA Premium Assistance is April 1 through September 30, 2021. Now, this is also a friendly reminder that compliance with ARPA COBRA Premium Assistance is not necessarily for lack of a better term, a one and done matter. This is very much ongoing. And so this timed nicely as our team was talking about providing an additional webinar to discuss the ongoing compliance matters with ARPA. And it only made sense to focus also on the recent guidance that we received. So switching gears here to this ongoing compliance requirements for ARPA so folks can refresh or know what still should be mindful of. And if you've joined us in the past, we've summarized the steps for compliance as 6 steps, and that would be understanding who the premium payee is, which we just, most of those Q&As clarified. Who are the assistance eligible individuals? Step 3 is sending the required notices, understanding the premium payment process, sending a notice of expiration of premium assistance, and applying for the tax credit. So the purpose of these next several slides is to reiterate that this is an ongoing compliance matter, and there are a few things to highlight to make sure that we're not missing. Next slide, please. So for the first step, who is responsible for providing premium relief to participants claiming tax credits as the premium payee? we have a solid foundation, and then we have all the further clarification that we just discussed through Q4 through 11 on the most recent IRS Q&As. But for those fully insured and self-insured employers subject to federal COBRA, the employer is the premium payee. But when we're dealing with a single employer plan subject to state continuation, not federal COBRA, the insurer is the premium payee. Now, we just discussed some clarifications to this in the instance where the employer is subject to both federal COBRA and state continuation. There are instances where the employer will be the premium payee. And for a multi-employer plan, the plan is the payee, premium payee. And then for MEWA, the common law employer would be the premium payee. The clarifications that Beth and I discussed from the Q&As would certainly apply. So we did get a little further guidance on the MEWA premium payee through this last set of IRS guidance. Next slide, please. And for step 2, who are the assistance eligible individuals? As you may know, if the initial COBRA triggering event or the reason for the loss of coverage is involuntary termination or reduction of hours, which can be both involuntary or voluntary, this could lead somebody to be an assistance eligible individual. And so if these things are happening, you may need to administer certain compliance obligations as it relates to ARPA. So the other things to consider are folks that are still in their maximum coverage period. And that would generally be folks who are in 18 months for federal COBRA, but as Beth mentioned in some of the clarifying guidance, that a disability or second qualifying event could also be eligible. State continuation can vary, and that includes new COBRA qualified beneficiaries. So again, folks who are currently experiencing an involuntary termination of employment or a reduction of hours could be eligible for premium assistance under ARPA, which would trigger employer compliance obligations. Now, the other step of being an assistance eligible individual would be that you cannot be eligible for other group health plan coverage. And we did just receive a slightly even more clarification here, where eligibility for other group health plan coverage or Medicare will, for lack of a better term, disqualify an individual for assistance, even if that new group health plan coverage eligibility or that Medicare eligibility doesn't provide that benefit in which that individual was enrolled in COBRA for. So the examples in the Q&A, I believe it's number 2, deals with dental and vision. If somebody is enrolled in COBRA for dental and vision, subsequently becomes eligible for Medicare or group health plan coverage that does not provide coverage for dental and vision, they're still ineligible. And then the fourth qualifier is to not be eligible for Medicare. We've received a lot of guidance since ARPA on clarifications with all of these, but the takeaway here moving forward is that if these events are happening, or if they have happened since April 1, that it does trigger compliance. It could trigger compliance obligations under ARPA. Next slide, please. And then, so the third step is sending the required notice. And this slide provides an overview of those required notices, which are the model general notice and COBRA continuation coverage election notice, the model notice in connection with the extended election period, there's a model alternative notice, and then there's a summary of the COBRA premium assistance provisions that is provided with the above 3 notices. And as mentioned, that these notices will continue to be required depending on qualifying events or losses of coverage that occur that would trigger premium assistance. So next slide, please. This gives a nice visual of where we're playing right now. So that first notice, the Model General Notice and COBRA Continuation Coverage Election Notice applies to qualified beneficiaries who have qualifying events between April 1 and September 30, 2021. So this very much is ongoing, right? But that second notice we graded out because it applied to those who are on COBRA on April 1 or were still in their COBRA maximum duration period. So that notice is likely has already been sent and not needed on an ongoing basis. And then there's the model alternative notice that will apply for those who are eligible for state continuation between that same time frame, April 1, September 30, 2021. So, keep in mind that notice requirements are still very much a thing and should be paid attention to as AEIs have their hours reduced or involuntarily terminated. And also keep in mind that these opportunities to elect could last actually throughout October. And what I mean by that, not to cause any confusion, is that keep in mind that folks have 60 days to elect. So a qualifying event, let's say an involuntary termination that happened August 15th or in September, could mean that an AEI has until after September 30th to elect that premium assistance that would be retroactive back to the loss of coverage or the date of the triggering event. And so a good takeaway here too is that if you're working with a third-party administrator or a COBRA vendor, you want to make sure you're communicating when these involuntary termination and reduction of hours happen, so the correct notices are being sent for ARPA compliance and COBRA compliance generally. So I'm going to kick it over to Beth to discuss those last three steps in the overall compliance with ARPA.
Sure. Thank you, Diane. And as Diane mentioned, if you have been on these calls, you will have seen these steps before, so they are not new. So I'm not going to go into like a whole lot of detail on these last few ones. But step 4 is just, the process of engaging in, basically requesting the premium payment, or actually paying the premiums on behalf of the AEIs. And so with this, employers are working with carriers and their COBRA vendors to make this happen. But essentially, someone who is an AEI who actually does take the chance to elect that coverage is going to be considered paid in full. Now, I saw on the Q&A a couple questions that I'll shout out. Sorry, Jill, I'm kind of making your job a little obsolete here. But I saw a question from someone who asked about someone who is an AEI who might not have completed the form and returned it, and whether or not that type of person should just be treated like an AEI and the employer pay for their coverage. And we would caution you not to do that, because that person might not have returned the form because they know that they're not actually an assistance eligible individual. So for example, if the employee or the prior employee is currently enrolled in their employer's group health plan coverage, then they would know that they're not eligible and they would not have sent that form back. So you don't want to automatically treat them that way. You do want to look for that form where they do actually request that treatment as an assistance eligible individual. But once they do that, their premiums are going to be paid. All of it, right? Up to 102% of the cost of coverage is going to be paid for them. They will not pay anything. The reason why I say that this slide is mostly still correct is because we do have some clarifications on, again, who the entity is that's responsible for paying the premium. And so those changes are ones that we highlighted with the question and answers that we dealt with that kind of changed or gave us some slight clarification on situations where it's the employer instead of the carrier. And then finally, employers who have those fully insured plans are likely paying for those COBRA premiums and then electing to, receive the credit through their tax process. Now, step 5, we're kind of coming right up on it. This conversation is very timely because there is the requirement to send a notice of expiration of premium assistance. So essentially, it notifies assistance eligible individuals that their COBRA premium assistance is going to end soon. Now, it's important to note that even though their COBRA premium assistance is going to end soon, their COBRA doesn't necessarily end unless they're at the end of their COBRA maximum duration period. And it's also kind of interesting because those people who will now have to pay for their coverage, let's say in October, because of the extension of certain time frames, might even have more time to pay. And so just keep in mind that you're going to want to consider the fact that those employees who continue on that COBRA coverage after the COBRA premium assistance is over, potentially, then they are going to have to pay for that coverage, but might have a little bit more relief depending on kind of what their situation is. Now, this notice has to be provided within 15 to 45 days before the date of expiration of the COBRA premium assistance. And the reason I said this is timely is because the COBRA premium assistance only goes through the end of September 30th, potentially. And so what that means is that 15 to 45 day time period before is really going to start about August 15th and then would end about September 15th, right? So you would only have that 30-day window through which you would provide that notice. And it's really going to be required for pretty much all of your AEIs unless an AEI basically comes and stops their premium assistance because they became eligible for a group health plan or Medicare. And so all of you employers are basically going to be sending this out to anyone who might be on premium assistance, with the exception of those who are no longer receiving premium assistance because they became eligible under a group health plan or Medicare. So that is something that should be going out. Step 6 is to apply for the payroll tax credit. And I won't go into a lot of detail with this because it gets real taxy. But the idea is that that premium payee can basically go through then and apply for the payroll tax credit from the IRS. If it's a situation where the employer's Medicare tax amount or FICA tax amount does not actually cover the amount in COBRA premium assistance that they provided, then the IRS can provide basically an advanced tax credit amount or a reimbursement, if you will, to that employer for that amount. But it's kind of interesting because we did get a question in that we chose to address in the Compliance Corner FAQ from the most recent Compliance Corner, which is that, if there's a situation where an AEI notifies the employer of election of this COBRA premium assistance in a quarter that is later, let's say, than when their coverage started, then generally that employer or premium payee is going to claim that credit in the quarter that they pay for the coverage. And so that's something that we addressed in a recent Compliance Corner article. And so that is kind of our discussion of the COBRA Premium Assistance program and kind of where we are now and what needs to be done. And so I'm going to send it over to Diane just to spend a few minutes talking about some of the other updates that we got from the ARPA and just giving you an idea of where we are on those.
Hey, thanks, Bob. And so it's timely to, as we remind for compliance updates on the ARPA COBRA Premium Assistance, to also mention some compliance updates or reminders as it relates to FFCRA Leave and the relief provided under for health FSAs, dependent care FSAs, and Section 125. Next slide, please. All right, so with FFCRA Leave, as a reminder, this applies to employers with less than 500 employees, was required from March 1, 2020 through December 31, 2020, but it was optional January 1, 2021 through September 30, 2021. And it provides employees with paid leave for reasons related to COVID-19 and 2 weeks of EPSL or emergency paid sick leave, and then expanded leave up to 12 weeks. It was 10 weeks, but effective April 1, 2021, it was 12 weeks. So a few things to note here, and that if an employer chose to provide paid leave, EPSL paid leave or expanded FMLA paid leave, it is eligible for tax credits associated with that paid FFCRA leave. It is optional though, so an employer after December 31, 2020 did not have to provide this. So the reminders here is that employers had options and it could have offered EPSL but not expanded FMLA, or vice versa, could have provided for expanded FMLA and not the emergency paid sick leave. And employers also had options to provide for a period of time shorter than January 1, 2021 through September 30, 2021. So an employer could have chose to allow this through July of 2021, if you will, or an employer could choose to allow this now through September 30, 2021. And then, frankly, an employer could have chose not to offer either, but keep in mind there are still maybe state considerations regarding paid leave to keep in mind. Another thing that the ARPA did was it expanded reasons in which to take paid leave, and that was in addition to those already provided under FFCRA, is to seek or await the results of a diagnostic test or a medical diagnosis of COVID-19, request that test or diagnosis, obtain a vaccination, or recovering from an injury, disability, illness, or condition related to the vaccine. So here, keep in mind, if an employer chose to provide paid leave as expanded by ARPA, that the tax credit is available for that leave through September 30, 2021. And then most recently, I think in June, we had a Compliance Corner article on this topic, and our most recent Compliance Corner included IRS guidance on FAQs or Q&As that relates to obtaining the tax credit related to paid FFCRA leave. So be sure to check that out if that's applicable for those employers who chose to implement this. Next slide, please. All right, and so as you may be well aware, there's a whole host of relief options that are applicable both actually to 2020 and 2021. This is a summary, and I'm just going to go over it on a high-level overview, but use it as a visual or an aha as a reminder to some changes that might have been made months ago, but we need to keep them in mind because there are compliance obligations associated with it, which we'll hone in on the subsequent slide. But through relief, there has been extended carryover or an extended grace period offered for health FSAs and dependent care FSAs. There are mid-year election changes that are permitted without a qualifying life event for plan years ending in 2021. And there's FSA relief for terminated and furloughed employees, where an employee who ceases participating in an FSA can continue to receive reimbursements from unused benefits through the end of the plan year in which the participation ceased. So this is a spend down provision of sorts, and it's applicable for the 2020 or 2021 year only. And then there was also DCAP relief for parents of certain children turning age 14, where expenses for an employee's child continue to be eligible for reimbursement when the child turns age 14. And that had specific applicability, but it in practice, really, it was a more relief for dependents who aged out of eligibility during the specific plan year that aligned with regular enrollment period for the DCAP that ended on or before January 31, 2020. And so with this relief, for those employers who chose to implement any of this relief, there are certain considerations to keep in mind. Next slide, please. So this is ongoing if the employer elected to provide it. Again, the theme of this, and I'm a little repetitive here, but this was optional for employers. All of those options that I just reviewed were optional for employers to implement. But if they chose to implement it, that plan documents do need to be amended. And as it relates to the FSA, DCAP, and Section 125 relief that we just reviewed, those amendments can occur by the end of the plan year following the change. So if there was a change made for the 2021 plan year, the amendment would need to occur by the end of the 2022 plan year. And other things that employers should keep in mind is that if you are offering that expanded grace period or carryover provision, that there will be impact to eligibility for HSAs in the subsequent plan year. So that's something we got to keep at the forefront of our mind there. And then just food for thought is that there's no indication here right now that this relief will be extended beyond the plan years to which it currently applies. We don't have a crystal ball, but we are often asked on what's on the horizon. And right now, there's no indication that we'll have an extension of this relief, but who knows? It's certainly intentional that, we didn't title this the last ARPA presentation and that we keep numbering it. But also a shameless plug for our optional or mandatory reference chart that goes through all of the COVID-related guidance for 2021 if you need a refresher. And next slide, please. And then here it's just a friendly reminder specific to that DCAPS increased exclusion. As you may recall, ARPA increased the exclusion to $10,500 for married filed jointly, and that's for calendar year 2021 only. And along with that, an employer could permit employees to increase their 2021 DCAP election up to $10,500. But in order to do that, the plan must be amended by 12/31/2021 in order to do that. So that's another plan amendment to keep in mind. And then note that amounts carried over from a grace period or a carryover that we just discussed on the relief from a 2020 plan year are disregarded for purposes of the application to the limits for the 2021 taxable year. Same is true for carryovers and grace periods from 2021 to 2022. And for the sake of time, if this is confusing you, do not fret. We have our handy dandy frequently asked questions document where the last few questions, I think 26, 27, and 28, hone in on the different guidance that we received specific to that DCAP increase exclusion. But keep in mind, right now, there is no guidance on an increased exclusion for 2022. So right now, the exclusion returns to $5,000 for 2022, and that is definitely something employers need to be mindful of. And with that, I'm going to hand it back over to Beth with some final thoughts and closing comments.
Thank you so much, Diane, and thank you everyone for sticking with us today to talk a little bit more about the ARPA. We thought we'd give some final thoughts, and first, I'll say kind of a few things we'd obviously want you to know. The important thing, especially as it pertains to the COBRA premium assistance, is that, employers should know kind of what vendors are going to take responsibility for versus what the employers need to take responsibility for. I bring that up because I know, as I mentioned, we are headed towards having to provide the notices that tell people that the subsidy is about to end. And my understanding is that there were a lot of vendors who said, okay, well, you can pay extra for us to us for you to send that. But employers might not have chosen to do that. And so those employers are going to have to take it upon themselves to make sure that they send that notice. And it's just really important that you kind of pay attention to who is doing what and meeting your obligations for you. Mind you, as Diane just discussed, we're potentially headed towards the end of this relief, but I'm sure all of you at least know a little bit about what's going on out there. So the COVID-19 virus, as well as the government, might have other plans for us. If they do make any changes, we'll continue to notify you if and when there are changes. As Diane and I have already kind of alluded to, there could be a need to have another one of these presentations, in which case we will provide that information to you. I will say, going towards the end of the year, whether or not this kind of stuff ends and does wind down, employers are going to want to make sure that they're actually documenting everything that was done. So, for example, with the changes that Diane just mentioned, having to do with the Section 125 relief that was offered, the plan documentation being amended and the changes to plan documents that need to be made is something that employers want to focus on, especially for those of you who have that calendar year plan where you're going to be looking to kind of make some of those changes and wrap up the 2021 year. And then finally, I'll just mention that, this is one of those things where you definitely want to take any participant complaints or inquiries seriously. Just as someone who has worked for a government agency before, I can say that with certain types of relief like this, there will be government enforcement of these requirements, specifically that COBRA Premium Assistance Program. I'm pretty sure that the DOL will be actively looking to make sure that employers did actually comply with the requirements that were were provided through the ARPA. And so you just want to make sure that you're staying on top of those and actually making sure that, you're addressing any issues that may be brought to you by participants. So with a grand total of 45 seconds left, Jill, anything you want to highlight or bring up before we kind of turn it back over to Amber to end the call? Oh, never mind. I think Jill is dealing with something else. So I will just say that, we thank you all for participating. A few of you asked about these slides. We are going to provide them. We always try to provide some resources on the slides. And so you'll see that on this last slide here, and you will receive an email in the next 48 hours or so that will provide the copies to this slide in addition to any other kind of information that we want to provide you. So thank you so much for coming. Amber, do you want to end it out for us?
Sure, thank you. Thank you, Beth and Diane, for sharing your valuable time and expertise with us today. Thank you also to our benefits compliance team for moderating the Q&A today. As a reminder, today's presentation was recorded and will be emailed tomorrow. The recording and the slide deck from this webinar will be posted to the nfp.com latest insights page under webinars training section. And that concludes our webinar for today. Thank you everyone for joining us and have a great day.